Good afternoon, ladies and gentlemen. My name's Adrian Ross from IT Governance. I am a GDPR consultant, so hopefully everyone is signed on for this particular webinar, which is Data Protection by Design and Default under the GDPR. Now, just before we begin, I'd just like to say that my colleagues in the marketing department will send you out a copy of the slides and a copy of the webinar broadcast in the next day or so. So the intention this afternoon is to spend about 45 minutes talking about this subject and then taking questions for about 15-20 minutes afterwards. And then, excuse me, if there's anything after that, we can email them into us and we'll deal with them as they come in. So, as I say, my name is Adrian Ross. I'm a GDPR consultant with IT Governance. I'll just go to the next slide. And just to say a little bit about myself, my background going back some, I guess now 30 years, covers all kinds of things like infrastructure services within the large financial institutions, United Kingdom, taking in projects that encompass things like business process re-engineering. I think in the 80s I was heavily involved in business intelligence, data warehousing, and then looked at things like business architectures, how businesses can operate more effectively. And then in the last 15 years I moved into intellectual property, and of course legal compliance plays a part in that. And then when I joined IT Governance a while back, I joined the information security side of the team and then assumed some responsibilities for data protection. So I think at the moment that makes me, apart from our founder and chairman, one of two people in the company that can actually do both subjects. And I think that's quite useful because they do run in parallel and they do overlap from time to time, so I can speak with some authority about both of them. And then more recently, in the last couple of years, I've taken a particular interest in enterprise risk management, and I've studied international risk management with the organization in London. And when I present our GDPR Foundation and practitioner courses, I have a particular interest and emphasis on reputation management, which is all good stuff for GDPR. Okay, so this slide is a little bit about us as an organization. I think we're currently about 250 people across the world, and we have offices in a number of different countries. Our background, if you like, started off about 15 years ago in the United Kingdom, and more recently we've opened an office in the USA and various other countries in the Benelux countries, other countries around the world. But as you can see there, that's pretty much how our organization is structured. I work in that top grey part there, which talks about information governance, risk and compliance. And then we have a strong presence in our cyber resilience team. Have a number of consultants who implement information security around ISO 27001. Business continuity is in that team with 22301. As you can see, we do lots of penetration testing, PCI DSS work. And then on the other side, again, my colleagues, they have responsibility or experience rather in things like COBIT and ITIL, project management methodologies such as Prince2. And then below that, we run lots of training courses and qualifications as an organization. We have some software tools, one in particular called VS Risk, which integrates with ISO 27001 and also GDPR as well. And then we have toolkits, and we publish lots of articles and different books on technical subjects within this particular area. But we have a GDPR toolkit just gone up for phase 2 release, and that helps particularly small to medium enterprise organizations really get to grips with all the different processes and various controls they have to implement to become GDPR compliant. As I say, as an organization, we work literally across the world now, and we work in all verticals, all sectors, all organization sizes. So in my particular field, I have some of the largest companies in the United Kingdom as clients, particularly financial services, pharmaceutical, motor industry, all sectors within all industries, and right down to literally startup operations, one-man operations. So very diverse client set, and that's one of the great things about working here, is that no 2 days are the same. Okay, so for this afternoon's webinar, the agenda is as follows. So we're going to have a very brief introduction to the GDPR, and I do say very brief because normally when I talk about this on our foundation course, this is about an hour and a half in itself, but then we're going to talk about data breaches, and data breaches are essentially what organizations get fined for. Then we're going to talk about the introduction of this new requirement in GDPR, and that is the requirement for accountability within organizations, in particular in relation to data protection. Then we're going to talk about privacy by design, which is a concept that's been around for quite a number of years now. And then privacy by design is reflected in the GDPR by something called data protection by design and default. And then we're going to talk about privacy compliance frameworks, what that looks like, and something called PIMS, which is a personal information management system, and really sort of is linked to a British standard 10,012, but I'll talk about that a bit more when we get there. And then talk about lessons for data protection officers, and also look at how the statistics can be interpreted in terms of what the GDPR or implications for GDPR going forward, and that's statistics in terms of what's happened all over the world in terms of data breaches. Okay, so let's begin by looking at material and territorial scope. Well, we talk about something in GDPR called natural persons. Well, this regulation is applicable to natural persons, and sometimes we call them data subjects, so one and the same thing, but essentially it's about living individuals. And those living individuals, we have rights associated with the protection of our data, personal data, protection related to the processing of that data, and processing is a very broad term, which I'll talk about a bit more. And then we have this introduction of the unrestricted movement of personal data within the European Union. Now, for those of us who are Europeans, that is very like our unrestricted movement of people, where people can move freely within the European Union, and part of this regulation says that we should also have that for data that relates to natural persons. What is in material scope? Well, it's data that's partly or wholly processed by automated means. And the question was clarified quite recently, what does automated means mean? And it means anything that's processed by a computer, but also telephony, covers infrastructure. So anything that's processed by electronic means. And so that's a very broad definition there. And also that second line there, personal data that's part of a filing system or intended to be, well, that covers the requirement to look after paper-based records, and there is a considerable amount of paper-based records out there in industry. I think the latest I've seen is one organisation that held 90 years worth, so there is a large degree of paper-based records out there. So this covers both electronic and paper-based records, particularly or especially where those paper-based records are part of a filing system, so they're indexed. If they're not indexed, then they fall outside the scope of the GDPR. And finally there it says in material scope, regulation applies to controllers and processors in the EU irrespective of where processing takes place. Well, I'll just deal with that in the context of that final footnote there, where it says it also applies to controllers and processors who are not in the EU. Well, really, if the controller or processor inside the EU processing data, for instance, in Australia, well, that's part of this regulation. If the controller or processor are outside the European Union processing data inside the European Union, personal data, well, they're in the scope of this regulation too. So it covers quite a broad, has quite a broad remit, if you like. Okay, so entry into force and application, well, there's a number of dates on there, but what those dates reflect is really the formal process that we take at a European level when we implement laws. So it has to go through a number of stages, including being published in the official journal. You can see there on the 4th of May, it then goes into, it then takes effect 20 days after that. So that's how we got to the 24th of May, and then applies 2 years from that date. So this is the formal process that we go through, particularly in relation to this regulation. And what we had prior to that was a directive. The directive that came out way back in '95 required each member state to implement its own legislation in response to that, and what we ended up with is 28 different data protection laws across the European Union, whereas the intention of this regulation, and as it says there, is it is directly applicable in all member states, and the intention is that there is increased harmonisation across the European Union, and there is no requirement for each member state to implement its own national laws. This regulation is applicable from 25th of May 2018, and therefore it is applicable across all the European Union. Okay, so natural persons, as we talked about a few moments ago, have rights, and we have rights to judicial remedy in the courts of the member states where the controller or processor has an establishment. Now, establishment is an old sort of legal word, and historically it meant something like head office, or factory or data center or something like that, a physical location, but actually means where economic activity is carried out, and that's what it means in the context of European law and in terms of data protection. We also have right to judicial remedy in the courts where the data subject habitually resides. So what that means is that the data subject can take legal action against organisations that are controllers or processors, either where they have their economic activity or where in fact the data subject lives. Yeah, and it applies to any damage, anybody that suffered material damage or non-material. Now, non-material in this case means things like hurt feelings, embarrassment, trauma, anything like that is in the non-material definition there. And in fact, most recently in 2016, one of the British courts made an award to someone on the non-material side, which was quite significant in relation to the award that was made on the material side, because historically it is quite difficult in data protection law to establish what the material figure should be. So the courts are now saying on the non-material definition, or within that they've had enough of organisations breaching data and causing people harm. So they're now starting to make awards under that particular criteria. Now, that final point there, controller involved in processing shall be liable for damage caused by processing. Well, what that's about is very common in data protection law to not be clear about whether an organisation is a controller or a processor, and in reality controllers can also do processing, and this is what this line is about. It's saying that we have an organisation that is a controller and does processing too, and there is a breach relating to the processing part, the liability is limited to that processing bit, if you like. Okay, so we have this new thing under, or this new definition under the General Data Protection Regulation, administrative fines. That's the introduction of those. We didn't have those before, but we talk about these fines being effective, proportionate and dissuasive. Well, that is a way of saying that the lawmakers intend organisations to take these fines seriously, and they will look at the effectiveness and proportionate application of those fines across the European Union. And that's a point I'd like to make, actually, is that this is a European law, and it's very much about the application of the law across the European Union. Okay, now the fines, when they are calculated, will take into account things like technical and organisational measures implemented. Now let me just cover what those are. Technical Technical measures would be technical controls like encryption or anonymization techniques, all the technical controls that we're all familiar with within our organizations, but also how those technical controls have been applied and the way they've been applied to protect the data of natural persons or data subjects. Yeah. Now, alongside that, we will also take into account organizational measures. Now, organizational measures will be things like how the organization approaches data protection governance, what kind of structure do they have in place, what training and awareness do they have in place, what kind of sort of logical controls like segregation of duties, how do they approach data protection, and that all comes under organization. How do they set themselves up to take care of data privacy? Okay, now there are two tiers of fines, 2% and 4%. I'll go straight to the 4% because that's by far the most important bit. And the 4% fine is 4% of worldwide annual turnover in the preceding financial year, or 20 million euros, whichever is the higher of those two figures. Now, the important point to get from this is that it's 4% of global turnover, and it's in the preceding financial year, which means that's usually a published figure. So there can't be any situation where an organization will come back and say, well, we had a bad year that year because they've already published that figure. And as I say, it's against a group of undertakings rather than an undertaking. It's a group of undertakings, and the very simple way to understand that is if you have 10 companies in the group, 9 of them are compliant and the 10th one breaches, the 10 are fined. Yeah, the fine is calculated against the turnover of the 10 companies. So you need compliance across the group now. So that's what that means in reality. Okay, so if the fines are all about breaches, let's take a look at how this works. Well, as you can see there, there's a definition. Personal data breach means any of that. So we've got accidental or unlawful destruction, loss, alteration, unauthorized disclosure, or access to personal data transmitted, stored, or otherwise processed. So this, of course, means that if we get back to what we said at the beginning, where we have controllers and processors in the EU processing data outside the EU, or controllers and processors outside processing data inside. So even if somebody accesses data, looks at data from outside the European Union, that is still regarded to be a breach. Unless, of course, they have that as part of their job. But if somebody can look at data from outside the European Union into the European Union, that covers a breach as well. Now, we have controller obligations here and we have processor obligations. Now, we have this time period of 72 hours after the controller becomes aware that they have 72 hours to notify the supervisory authority. Supervisory authority in the United Kingdom is the Information Commissioner's Office. Supervisory authority, the words are as the term in the GDPR for all the regulatory bodies across the European Union that look after data protection. So they're all going to be supervisory authorities, and they, on their notification of a breach, have to describe the nature of the breach, whether it's sensitive data, how many records, what the implications are, and if they fail to report that breach within 72-hour period, they have to provide an explanation to the supervisory authority. Yeah. Now, just to qualify that third point there, there's no requirement to notify the supervisory authority if there is no risk to the rights and freedoms of natural persons. Well, some of you may be saying, well, what does that mean? It basically means in GDPR terms, sensitive data. Yeah, so there is not a requirement to notify if it's not sensitive data. However, some organizations that we've worked with in the United Kingdom choose to notify anyway because they want to be seen to be doing the right things. And in fact, we had a client last year who breached 150 records of sensitive data, notified the supervisory authority in the United Kingdom, and they worked with them to resolve that situation. There's no fine in that particular example, but so we always have processor obligation. We also have processor obligations too, and there is an obligation on the processor in terms of breaches to notify the controller always and without delay, and that's important in there. As it says there on the second bit, there are no exemptions to this, and between those two we have this term in the GDPR called undue delay, and you know, it's more within the controller side of things at the moment, but they say that the controller has to notify the supervisory authority with an undue delay, and that's still to be clarified what that means, but we very definitely have the 72-hour period. Okay, so we've got our data breach, and there is an obligation for controllers to communicate the data breach to data subjects. Okay, now that first point there is communicate to the data subjects without undue delay if the breach represents a high risk to data subject. Right, so we're back to this sensitive data again. Any communication with them has to be in clear, plain language that they will understand. Now there are some exemptions to that I'll just drop down to below, which says exemptions are if appropriate technical and organizational measures were taken. Well, what that means, if we've technically had a data breach but the data is encrypted, so therefore we can't identify the data subjects, then we have an exemption from notification. Or if the high risk to data subjects will not ultimately materialize, so that's where we've had a partial breach and we've not got to the stage yet where we can identify an actual person of the data subjects, or communication with data subjects would involve a disproportionate effort. The only thing I would say about that particular line is that there's also a line in the GDPR says that organizational controllers can use a public communication, so a press release or something on the website to communicate to all the data subjects as a group. So coming back up then, the controller may decide that, you know, in relation to this particular breach, that one of those exemptions apply. However, that third line on the top half of the screen says, and it is true, that the supervisory authority may overrule that decision and compel the controller to communicate directly with the data subjects. It might be that they decide that the breach is serious enough that data subjects need to know. Okay, so let's look at some of the breaches or data breaches in the United Kingdom. Well, as you can see, this is 2016 data, but I think what's quite relevant in here is the data breaches by sector, and this information has come from the Information Commissioner's Office, but you can see there's quite a high level of breaches in the health sector, and one of the reasons for that is that we have you already have mandatory breach notification in that area. So every time there's a breach in the health sector, they have to notify the UK Commissioner's Office, and that's why the figures are so high there. Public sector also, there's an administrative requirement to make notification. The other sectors in there, in effect, are voluntary notification of breaches to the Information Commissioner's Office, or what will be the supervisory authority. So as you can see there, over the 448 new cases, that's how they were split across the different sectors. Health, of course, has a high degree of sensitive data, as does local government, as well as may well be the case with legal profession and various other sectors there. Okay, so when we look at this from a cyber breach perspective, 69% of large organizations and 38% of small organizations suffered breaches in 2015. So at a cyber level, there's a very high level of breaches going on, and I think also since 2015, I think we've seen cyber activities and cyber breaches go up exponentially in terms of the seriousness of, I think we had one probably about a month ago now with our own National Health Service, where we had denial of service to most of the health service in the UK. As you can see there, there's some statistics from PwC that says, you know, the average cost of a single breach in a large organisation is 1.4 to 3.14. Actually, I would question those figures, because some of the clients that we have spoken to in the United Kingdom end up making far bigger provisions in their finances to deal with breaches. And I'm talking particularly more about the ones that are, you know, where the information has got out into the public domain. So where there's clear lack of controls internally, they need to spend a lot of money to fix that. Okay. And generally speaking, organisations expect more breaches than last. Well, as I said earlier, since 2015, I think we would all agree that, you know, whichever newspaper it is we pick up in the morning, or whichever email or feed that we listen to or look at, you know, breaches are increasing both in frequency and in seriousness. Okay, when we look at the breakdown of these breaches, just go back there, almost 70% of them are from external sources. 37% denial of service, and I believe that's what we had with our National Health Service a few weeks ago. And you know, even going further down, you can see staff-related security breaches, and there is some statistics around the United Kingdom about you know, intentional breaches, and this tends to be from disaffected staff or employees. Yeah, and then in inverted human error, I mean, that's very simply just sending the wrong stuff to the wrong person, the wrong data. Okay, so when we look at these cyber breaches from another perspective, what the important point here is they're affecting all sizes of firms, from micro right through to very large firms, and average number of breaches during the year. As you can see, the bigger the organisation, the bigger the average, and you can see the numbers associated there at the bottom. So there's quite a lot of this stuff going on all the time. Most of what's happening is to do with viruses, spyware or malware, and then now we're seeing the emergence of other organisations making impersonations on emails and online activities. So there's quite a bit going on in the cyber world at the moment. So let's talk about accountability under the GDPR. Well, what does it mean? Well, what it means is that, you know, we have these data protection principles that we've had in data protection law for some time now. At the moment we have 8 in the United Kingdom. They're now going down to 6 within the GDPR. It doesn't mean that we've forgotten about 2, because the other 2 are now folded into the regulation. And the important change on this particular slide is principle 1, where we have increased transparency, and that's the big change on the first principle there, but also the introduction of this term called accountability. And accountability is how an organisation applies the data protection principles as a whole within the organisation. Okay, now the Information Commissioner's Office in the United Kingdom has given a talk on this subject, because people were saying, well, what does it actually mean? And what they're saying is it's not about doing it as a box ticking exercise. It's about implementing a framework, and we call that a privacy compliance framework, that builds a culture of privacy within the organisation. And I saw a comparison I think from the ICO as well, where they said it's a bit like health and safety, where data subjects or employees or customers can work with an organisation, and rather like we all know that our health and safety is taken care of, is we all know that our privacy is taken care of. Okay, so how does that work through in the GDPR? Well, it mandates organisations to put into place comprehensive but proportionate governance measures, and that's quite an important phrase there, because it does have to be comprehensive, so that it takes into account internal controls, security controls, data privacy, but also looks at things from the outside in as well, and that involves some form of cyber resilience. Yeah. And proportionate governance measures, well, that means that, you know, not every organization is the same. And I think I mentioned earlier, some of my clients are big financial services, so they have something called the 3 lines of defense, which is a control framework that they implement. Well, clearly that's not relevant for smaller organizations, and it's all about implementing what is right for the organization that you work in, but also you have to comply with the law. So you need to come up with a framework that works and protects the data that you look after in relation to the particular risks your organization faces. Okay, and people also say, well, is it a cultural change? Well, yeah, GDPR is a cultural change because now we're having to take data protection very seriously, and you know, we just can't slot it in as part of some kind of system that's implementation that's taking place. It has to be from the top down, as we've experienced in information security for a number of years. If the CEO doesn't believe in it, why would anybody else? Okay, so it's all part of the overall systems approach to how it manages and processes personal data. So let's talk about privacy by design. Now, privacy by design is a concept that has been around since about the 1990s. It originally came out of the Canadian Data Protection Commissioner's Office, and way back in 2010, they, along with a number of other countries, encouraged the adoption of the principles of privacy by design. So we have data protection principles, but we also have principles for privacy by design. And way back then, they started to foster the adoption of these 7 foundational principles into the legislation of or the jurisdictions of each country that would sign up to this, up to adopting the principles. So they were very much educating the world about how to make changes in national laws to incorporate these principles. Then the Federal Trade Commission recognised privacy by design in 2012, and of course in the GDPR it is incorporated by the European Commission, although we call it something slightly differently, slightly different rather. Okay, so we have our 7 foundational principles. Well, the first principle is proactive, not reactive, and this is about us being preventative with the design or designing into our systems, controls that prevent things happening, so before the fact rather than afterwards. Yeah. And then we have an approach that is called privacy as the default setting. Well, we all know that if it's the default, everybody, or default rules, as they say within organizations. So what we're doing here is seeking to deliver the maximum degree of privacy, but by ensuring that all personal data is automatically protected in any given IT system or business practice. Yeah, so if the individual does nothing, they know that their privacy still remains intact. Yeah, so it's built into systems by default. Then when we look at privacy embedded in design, what we mean there is it's embedded in the design of architecture, systems, business practices, and we're not bolting it on as an add-on after the fact. So therefore, privacy becomes an essential component of the core functionality that's being delivered. It's integral to the system without diminishing functionality. And then we've got full functionality, positive sum, not zero sum. Well, what that's about is saying that there are no trade-offs, there are no unnecessary trade-offs, so we're not trading off security for data privacy and vice versa. Yeah, we're demonstrating that it's possible to have both in the organization. End-to-end security, well, that's full life cycle protection. So that's start to finish privacy throughout the organization. Whichever whichever bit in the life cycle the data is protected, and covers things at the end like security, and we cover cradle to grave life cycle management information right to the end. Visibility and transparency. Well, that's all about whatever the business practice or technology that we're using, it is in fact operating according to the stated promises and objectives and subject to independent verification. Yeah. Everything's visible and transparent to the users and the providers alike. It comes back to the old saying, trust but verify. Remember, trust but verify. Respect for users' privacy. Well, keep it user-centric. Right, so we have strong privacy defaults, appropriate notice, and empowering user-friendly options across our systems, and essentially keeping it looking at it from a user's perspective, making it user-centric. Okay, so we have this thing called trilogy of applications, and this is where we can make the biggest changes. So in information technology, what we're saying here is technology in itself is not a threat to privacy. The key is how we use it. Yeah? So within that, we can use various techniques to sever personal identifiers from data, encryption, all these techniques. And then as technological innovations come along, we can use these to minimize the threats to data privacy going forward. Accountable business practices, well, that's all about implementing serious privacy measures within the organization. So really what we're doing there is we're changing the emphasis from privacy being a compliance issue and making it a business issue. Protect the business, increase, and by doing so, increase competitive advantage. Okay, so finally, physical design and network infrastructures. Well, that's even at its most simplest level about things like physical controls, making sure that, for instance, when someone comes into, a particular office environment, that they can talk about things in a confidential way. Patients can talk about, medical conditions in a confidential way in the doctor's surgery. And making sure that even simple things like data that's stored away in filing cabinets and stuff, that data is locked down and secured. Yeah. But also covers things like logical controls as well, logical controls to systems. Okay, when we look at application areas, well, there are a number of papers that have been produced on the subject, and it covers all these different areas. And I think in terms of GDPR, the one that rings out most immediately is big data and data analytics. This is now going to get a big focus, certainly under GDPR, but also other regulations that are coming down the line. And I think most recently, I saw that Vodafone in the United Kingdom is one organisation that is actually starting to, rather than interview employees, they are videoing them and then letting artificial intelligence make decisions about who to employ. And in fact, it even went as far as saying that they're actually selecting management by using this technique. Well, this is all profiling using artificial intelligence, and this is all coming through, and this is all part of privacy by design application areas as well. So who is this relevant to? Well, I mentioned earlier that we talked about accountability. Well, who is accountability applicable to? Well, it's applicable to everyone in the organization from the very top down. And what we are seeing in IT governance most recently is that, CEOs and chief operating officers now are really starting to engage with the importance of implementing the GDPR and the risks and consequences of not doing so. The key candidate in all of this will be data protection officers, because they will have to articulate data protection by design and default to a number of different actors in the organization. And so they will have to liaise between the board, the data subjects, IT, compliance, risk, all these various pieces of parts of the organization. Risk managers, well, it's important to them as well, because if we do data protection by design properly, then we reduce our risks. There's also implications for the legal team. Then designers, analysts, engineers, computer scientists, and application developers, well, these are the folks that will need to be building this into our systems. Not only our new systems, but also taking a look at our legacy systems, which I'll talk about in a minute. Okay, so ICO has an overall systems approach, and as you can see there, taking into account nature, scope, context and purposes. Well, how complex is this for your particular organization, and particularly looking at the rights and freedoms of natural persons, being able to demonstrate this through appropriate technical and organizational measures. State of the art, well, that second point there, the GDPR doesn't define what state of the art is, but there are in fact, I had this conversation with someone the other day that even now we can just say that encryption is no longer state of the art, it is a standard within the industry, and that would be one thing that we would need to look at implementing within an organization. And there are various standards of encryption, so we need to get the right one for us. And then finally, controller has to implement technical and organizational measures for ensuring that by default, so there is the word default coming through, only the personal data is necessary for each purpose is in fact being processed. Well, we'll talk a little bit about that more on the next slide, because Article 29 is the article within the GDPR that talks about data protection by design and default. And as you can see, there's some of the, gives you some idea how to go about doing this, about the obligation applies to the amount of data collected, the extent of the processing, period of storage, accessibility. So all these things need to be taken into account within the umbrella of data protection by design and default. That next point, personal data is not made accessible to an indefinite number of persons without the individual's intervention. Well, that is a default position, and that's basically saying our default position is that our data is private to us as individuals. There are recognized techniques such as pseudonymization and minimization, and you would also include encryption in there. Anonymization too would be other techniques that we can use to protect data by design. Okay, so we have a tool that we use in the GDPR now called the Data Protection Impact Assessment. And I often describe this to people as a very comprehensive risk assessment that we undertake as organization. Now there's three words on that first slide there that I'd just like to highlight for the attendees' benefit. There's the words confidentiality, integrity, or availability. Now those three words, for those of us who have a history in information security, mean international data protection or data security standards like ISO 27001. The GDPR itself doesn't mandate any particular standard or any particular level of encryption, but those three words are the three words that jump out and say information security standards. So therefore, a data protection impact assessment is a subset of an organization's risk management framework. It is not the risk management framework, it is a bit of it. Draws on experience and understanding that's already within the organization, and then from the conclusions of our data protection impact assessment, we fold into our existing risk treatment plans. Well, in our data protection impact assessments, one of the things we do is we do a risk assessment, and then straight afterwards we do what is in effect risk treatment. Yeah, and by doing this we're demonstrating data protection by design and default. And as it says there, DPIA should already be part of risk management as normal. Now what I would say is some organizations have already started to do these before 25th of May next year. and the reason being they see it as a tool to really get a grasp of the risks for the organisation. Okay, now data protection impact assessment, the data protection officer plays a key role in all of this. He or she may not be the person who actually does it, but they are the person who assures that it has been done properly. Okay, now DPIAs may cover multiple processing risks or operations, so anything that's automated, anything that's on a large scale or publicly accessible, yeah, is look at those particular scenarios. And as it says there, a single DPIA may address sets of similar risk operations that present similar high risks. So really, the DPIA is not a one-off exercise. It is something that we're consistently running all the time for different things within the organizations. And the best way to think of it is if we've got any system that is going live or a new architecture that's going live or we're launching a new business process, data protection impact assessment is essential. And as I say there, it's conducted for all new systems and processes. And we of course must remember, and you know, those of us who are a bit older in the industry will remember that you start off with a project and you have a live date a year in front, and what happens along the way is the functionality changes, it increases, decreases, or we have scope creep or whatever, and of course we have to run this DPIA again, because otherwise we're not doing a proper risk assessment. So we're constantly re-evaluating the risks of systems going live, and of course should be conducted on legacy systems too, because there are lots of legacy systems that have been out there for decades now. In fact, before, you know, the concept of privacy by design or data protection by design and default came along. So we should be running DPIAs against legacy systems too, and working out what are the risks, the privacy risks associated with those, and updating the risk register and any project plans. And let's not forget that the approach adopted, by adopting this approach, the constant use or implementation of DPIAs would go towards any breach mitigation, because this is something that the supervisory authority would take into account when assessing a breach, whether or not you are running DPIAs. Risk assessment should be part of staff training. Well, if we're going to be assessing risks, well, people need to know what that's all about. Risk, I think I mentioned earlier, is part of my skill set, and risk people, professionals, tend to have their own language and what that all means. So we need to make that part of staff training. So the application of DPIAs demonstrates accountability. Okay, it's hard to say that we're demonstrating accountability if we're not doing data protection impact assessments. So privacy compliance framework, I touched on this a bit earlier. Each organization needs a privacy compliance framework, and that privacy compliance framework takes care of governance, it takes care of privacy principles, but also policies, procedures, controls and records, and this comes within something we call PIMS, Personal Information Management System. Now in the United Kingdom we have a standard for that, which is British Standard 10012. And what we're doing by putting this framework together is making sure that we can actually deliver privacy by design and default. And again, as I said earlier, this needs to be tailored to the risk profile of the organization that we're dealing with. Okay, recitals. Well, recitals in the regulation set out the context of why we're doing things, and it says here that controllers should adopt internal policies which in particular meet the principles of data protection by design and default. So we need that within policies. And then that second one, 108, when we talk about adequacy decisions, well, that is particularly relevant when we start to transfer information outside the European Economic Area. So this recital 108 is talking about the principles of data protection by the design and default when we transfer information across the world outside the EEA. So we've got policies and we've got mentioned in data transfers, and also within various other articles. I'll go straight to Article 47 here, because we have a mechanism for transferring data outside the EEA, and that mechanism is called binding corporate rules. And even if you look at Article 47 there, competent authorities, supervisory authorities shall approve binding corporate rules, provided they apply to general data protection principles, and at the end, data protection by design and default. So it's data protection by design and default. It's not just within the organisation; it is out with the organisation, particularly where we're transferring information. And this is a supervisory authority, saying that when they approve binding corporate rules for transfer information should also include data protection by design and default. So data protection by design and default permeates its way through everything the organisation does. Okay, now what are the lessons here for data protection officers? Well, we can have GDPR compliant documentation within our personal information management system, but we still need an effective ISMS, and that's an information security management system, and specifically we're talking about ISO 27001. We have lots of experience with IT governance, and we can say that where people have an effective ISO 27001 implementation, it is much more effective when dealing with breaches containing things like reputational damage and avoiding data subject actions and significant penalties. Yeah, accountability, genuine top management engagement is essential. Well, as I said earlier, if the CEO doesn't believe it, why should anybody else? Okay, within that, DPOs have effective independent oversight and have to be able to proactively engage with cybersecurity teams. They must be able to articulate privacy by design to the different functional areas of the business and explain why we're doing this. So a business risk-based ISMS, does exactly that. It's an essential component of the privacy compliant framework. Data protection impact assessments. Okay, now lessons for organizations. Well, I think this is quite an important slide here, because the statistics I showed you earlier in terms of breaches, and particularly in the United Kingdom, rely heavily on an administration requirement in our own public sector. So there is an automatic notification within our public sector. Within private sector, it is in fact voluntary, and in fact, the educated view is that in fact the number of breaches are far in excess of the ones that we looked at earlier, because a lot of organisations are just not making notifications in the private sector. So from 25th of May next year, we have this mandatory data breach reporting under the GDPR. Remember, we had this 72-hour period. So if we're going to have mandatory data breach reporting across the piece, that's both private and public, it's logical that the number of breaches will go up. The number of breaches that are reported will go up. And in fact, this would follow a pattern that was first seen in the United States, where when mandatory breach reporting was brought in, actually it went up quite significantly, massively in fact, I would say. Therefore, if the number of breaches are going up, or the number of reported breaches, it follows on that there will be increased enforcement. One of the things they will look at when looking at what has happened, they will obviously look at technical or organisational measures, but they'll look at the application of data protection by design and default. How has that been applied within the organisation, if at all? And there'll be increased fines for not demonstrating accountability. And the thing, of course, with data protection by design and default, it takes a while for the benefits to come through and to be realised. So it's a kind of medium to long-term return. And what we are seeing at the moment in the United Kingdom is already organisations that are going live with projects over the next 12 months are saying, right, let's stop and take another look at this. Let's look at this from a data protection by design and default. Does it conform to this data protection by design and default? If it doesn't, we're just storing up, and in fact maybe making an issue more serious by going live without it being built into the project as we go forward. So a lot of organizations now, and some organizations who I would say had quite a high risk appetite, are now starting to rein in that risk appetite and say, we're going to look at this going live now, and we need this built into our project plans. Otherwise, there's a big risk that organizations will fail going forward. Okay, so the GDPR requirement is controllers must implement appropriate and technical organizations. And I will say this applies to processors too. Okay, so policies, codes of conduct, ISO and BSI are both developing GDPR focused standards. Well, that's ICO, Information Commissioner's Office, is looking at one of a number of authorities across Europe looking at a European data protection seal. BSI, the British Standards Institute, already have the PIMS standard, or the BS 10012. ISO 27001 is an international standard that meets the appropriate technical and organizational measures. Interestingly enough, the BSI 10012 standard that I mentioned earlier, ISO 27001 was a British standard originally, so maybe the BS standard will become an international standard too. So ISO 27001 is one of the frameworks that we can implement that gives assurance to the board that things are being managed in accordance with the regulation. And as it says finally there, manages all information assets, all information security within the organization, protecting against all the threats. So within IT governance, there are, just finally wrapping up now before we take some questions, there are a number of various publications. I would particularly recommend the implementation manual there as being one that, having got some feedback, people have found very useful. And then I say we have Toolkit. There's another compliance gap assessment tool there that you can very quickly download and work through that with your organization and get a feel for where you're at. In terms of training, we have a number of training courses, and we run these all across Europe, and also and Channel Islands. We've done quite a lot of this. And now what we have in the United Kingdom is organizations putting, 100 people through these courses because they recognize the importance of GDPR. So the 1 day is an introduction to GDPR, the 4 day is an accredited practitioner course, and that looks at things from a data protection officer's perspective, and is heavily case examples we have in there that we work through continually, and by the end of the week people have a very good understanding of what is required. And in data protection impact assessment, that's a 1 day standalone course that we do as well. In terms of what we're offering to the market, one point I'd like to make on this slide is when you implement 27001, you define the scope of that implementation. The scope of implementation for GDPR is largely determined by the data footprint within the organization. As you will appreciate, an investment bank has a different personal data footprint from a large commercial retail organization. So, every organization has a different personal data footprint. So that determines wherever you've got personal data, that falls within the scope of the GDPR. So we are doing a number of things in this area. We're doing data flow audits, which is working at what data you've got, where it is, where it's going. And what we find within that is that organizations, without exception, have much more data than they think they have. Then we do a gap analysis that works out where are you at the moment. Incidentally, most of the organizations in the United Kingdom are not Data Protection Act compliant. And in fact, we had one chap who came to us with 40 companies in the group, and he said none of them were Data Protection Act compliant. So a lot of work to do there. Implementation of personal information management system, we're also doing that with organizations. 27001, we've been doing that for a number of years now, as is the same with cyber health check. So a lot going on there. As I say, we're just going to go in a question and answer session now. There you have my email address, so if you need to email me directly, that's my email address. As I mentioned earlier at the beginning of this session, my colleague will be sending you out copies of the slides and how to get the recording. So I'm just going to open up for questions now. Okay, so we've got questions now coming in quite heavily. I'm just going to go back to the start. What is the minimum encryption requirements on databases? Well, the GDPR doesn't mandate any particular level of encryption. It's for the organization itself to determine that the encryption that they have implemented is adequate for the risks associated with what it is they're trying to protect. Okay, so that's for Simon. Mentioned a court award in 2016. Was this under GDPR? As you've not been told, it is enforceable until May 17. Yes, right. That's quite an interesting question. That award was made under the current law, which is the Data Protection Act 1998. But of course, when we go live with the GDPR, it is in effect something like, if you like, ground zero. You know, so we start moving forward with a new set of rules. But all the case law that has gone on before that particular date is all relevant. Yeah, so for instance, how we've got to classification of sensitive data or personal data, non-conformance with particular bits of regulations, that all gets carried through. Sensitive data, Bruce, there is a definition in the GDPR that talks about sensitive data, but essentially we're talking about things like race, ethnicity, political orientation, sexual orientation, trade union membership is all in there. So all the what I call touchy-feely subjects. Sensitive, so Antonio, that's in there too. Name, telephone and email, well, those will all be classed as sensitive data, or personal data rather. Let me just go further down. Wayne, you've asked about the 72-hour period. Well, there is stuff around to say that what you're asking is correct. I suggest maybe you go and have a look at some of that. It's online, or send me an email and I'll see if I can send you something. Yes, it's definite. Processors do have to notify the controllers all the time. What does GDPR mean to marketeers, specifically email marketeers? Well, there's a lot going on in this particular area, Tim, and I don't know whether you've noticed or not, but there's been a lot of fines recently for organizations that are retrospectively trying to align their consent. Consent is a big change in the GDPR, and what these organizations have been trying to do is email people to get consent for something they should have had consent for already. And, you know, the ICO in the United Kingdom has quite rightly said, well, you know, that in itself is marketing when you do that. So these organizations have been fined. And of course, the other question is to do with bought-in lists, organization that buy in lists of people they can contact. Well, the obligation is on the organization buying the list to ensure that the information that they are being given is being passed across in the right circumstances, i.e. the person whose information it is had consented to that information being passed across. What would I look for in the software application to help meet privacy by design and default? What I would say, I mean, I'm not a technical software person, but really where this comes, most of the time when we talk to about data protection by design and default, we're talking to software developers, application developers, program managers, project managers, and they all recognize what it is they do. This doesn't seem to be something new to them. And one aspect that we have seen is, for instance, we go to one organization and that organization is heavily project managed, if you like. They have a great deal of competence in the project management skills. And when we ask them, well, how do you deal with data protection or privacy by design, they say, well, we do that last in the project cycle. Well, data protection by design and default is about doing it first. When you sit down with a blank sheet of paper, first thing on that sheet would say, right, how are we going to look after privacy? So there are various techniques in there. I mean, pseudonymization would be one that would spring to mind, where we disaggregate data in a fashion that we cannot identify from whichever data set we're looking at who the data subject is. So by utilizing a technique like that, we can protect privacy for individuals. Has a decision been made on consent? What qualifies consent and age of consent for the UK? Well, yes, there is in fact a paper that's been recently produced, James, and it's up on the ICO website. It goes through consent quite clearly. There is something new in the GDPR called explicit consent. Doesn't actually say what that means or set out a definition, but what it means is that we have to be more clear than organisations have been in the past. And I say to people, well, I have to be black and white. There's no ambiguity or any confusion what the data subject is consenting to. More specifically, more directly, pre-tick boxes are out, as is the double negative, which means you have to untick this box to remove yourself. So that's going. And this, one of the challenges that organisations are having to deal with is, first question is whether the consent that they have at the moment is valid, and that may or may not be the case. And if it is the case, what do they then need to do to get it to the higher standard within GDPR? And there is a definition in there. It has to be clear, affirmative, unambiguous. When a data subject gives consent, we must also provide a mechanism for them to withdraw consent, and it has to be on the same medium. So if we are getting consent online, we have to provide a mechanism online for the data subject to remove that consent. So as I say, that paper is worth looking at. There's a question here from Jerry about smaller companies can't afford to implement 27001. I would say ISO 27001 doesn't have to cost a lot of money. In fact, one of the challenges, or one of the clever things with ISO 27001 is to do the bits that get you the biggest return. And in fact, we've done it. I've done it personally for one or two man organizations, and fairly cost effectively. I mean, if you go into the IT governance website, Jerry, you'll see there are various options to implement 27001, and we have a range of offerings from you do it yourself to we do all of it, and we have a range of them in between, so we can get a little help, get a lot of help, but it's not a lot of money to do that. And one of the misconceptions of 27001 is it's a huge undertaking. Well, it can be if you go down that route, but also you can implement it quite cost effectively. What are the highest barriers for organizations? Is it culture, or is it dark data, or is it silos between areas that... I think the highest barrier, I don't think we should underestimate the importance of legacy systems here, because, like I was touching on the fact that there's probably about, I know at least one organisation that's got 90 years of paper records. I know at least one organisation that's got legacy systems that are 30 years old. Now, there might be a counter argument to that to say that, well, we've had 30 years to bed these things in and down. Yeah, but the world is changing quite rapidly, so we need to look at those. It is a cultural change. It is partly hearts and minds, and provided you've got buy-in from the very top, and I'm talking CEO, an operating officer, and look at the role of the data protection officer a bit more. I mean, we have another webinar on that subject, but the data protection officer is a very important job now, and one of the things he has to have is direct access to highest management. So it's all about putting the right structure in place for the organisation. I think the big challenges are consent is a big challenge now. Pretty much every organisation is having to look at consent because of the change to the data protection principle 1, increased transparency. All privacy notices are going to have to be redone. That's fairly common amongst all organisations. Retention of data is now coming into focus as something that needs to be looked at. You know, so those are, I would say, the main things. Also, I would also say breach notification, have a team that deals with, you know, a very clear policy procedure about how to deal with data breaches, because that as soon as that happens, you know, you're on the spot. An organisation that can deal with that, and those are typically organisations that have some kind of framework like 27001 and know who's doing what, and the procedure and the process can get through it. Other organisations, there's statistics where they've got nothing, they've gone out of business overnight, yeah, because nobody trusts them anymore. Okay, let's have a look. What protection do processors have against controllers who refuse to take appropriate precautions? Well, actually, when you look at the regulation, the standard of implementation of technical and organizational measures is the same on both types of organizations. And, you know, really what I would say, if I was a processor, in fact, we had this question the other day, now that I recall, and this was an organization that was a processor and was a very successful processor and dealt with lots of controllers. So their whole business was about processing, and the question that was raised was, well, how do I make sure that the controller doesn't drop the ball? Well, I suppose on one level, you see, the thing is, the processor should be acting under the strict instructions of the controller, and that's normally set out in a very clearly, tightly defined contract. So if I was a processor, I would want to ensure that that contract was very clear and that I was happy that didn't expose me as an organization. So I wouldn't want a wide contract. I'd want a very narrow contract that said what particular types of data I had to process, when I had to process it, what I did with the data at the end, etc., 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 and protect the organization that way. But you know, what's clear within this organization is controllers and processors are going to have a dialogue with one another, and both should be approaching it with the same intent. Who can be a data protection officer? The article, there should be no conflict of interest and rules out certain officers. Right, so what that's about, data protection officers, is there has to be no conflict of interest, and that's correct in the question, Andrew. But what's important there is this data protection officer role is about assurance. Now, if it's about insurance, it means that he cannot sit with an IT delivery or any delivery functional part of the organization that is going to conflict with his assurance responsibilities. Yeah, and you're absolutely correct. For smaller organizations, this may represent a problem. Yeah, I totally get that. And, you know, usually it's where somebody says, well, I'm doing the information security officer's job, and it, you know, it kind of makes sense. I'll do the DPO, but does that not make me conflict me with that? And I would say in that particular situation, no. I think because the two things are complementary. But clearly, if you've got responsibility to deliver IT systems on a given deadline, you know, that involves personal data, I would say it does conflict. Okay. So then one more question, I think. Cloud companies, Angela. Well, now that processors are in the scope of the General Data Protection Regulation, at the moment they're not in scope with the current legislation, but GDPR brings them into scope, and of course this brings in some of the biggest organizations in the world. So two that spring to mind would be Amazon Web Services and IBM Global Services. And as processors, that you have obligations under this regulation. Is the controller the customer? Well, the controller is a controller, processor is a processor, and in terms of a breach, whoever makes the breach will be liable. Yeah. Okay. What impact will GDPR might have in the mergers and acquisitions since people are buying customer data? Yeah, I mean, that's quite an interesting question, because when one organization acquires another organization's, one of the things that it should be doing is something called due diligence. And due diligence, we would suggest, goes on to look at things like data protection governance, information security. Why would you acquire a company that didn't do that well or did it badly? Because then the acquiring company is putting itself at risk. Yeah. Okay, folks, so thank you very much for that. We've gone sort of well over our time. If there's any other questions, I believe there's a mechanism where you can send them in. I think you've got my email address, and I'll deal with them. Forgive me, I'll have to deal with them when I'm on the road, but if you do send them in, it's been great. Hopefully you've got some value out of that. Thank you very much. Goodbye.